Hey everybody, Jason Burmis here, and as many of you, most of you now know, Ghislaine Maxwell has been denied bail, and she has pleaded innocent in a trial that is supposed to take place in July of next year. Who knows if we'll get there? Who knows if it'll get postponed? A lot of different questions. Before all this, there was a lot of speculation out there that maybe she was actually going to get bail. Maybe she was going to be able to jump the shark and get out of here. I didn't think so. You know, you still talk about people trolling my comments saying, still no mugshot, when many people in the courtroom saw her, described her via this video conference. Now, what I want to do is I want to go through the actual paperwork that was put forth against detention, or for detention, so she could not get bail, bond, whatever. It's a pretty fascinating document. It's only 18 pages long, so we're going to read the vast majority of it. I'm going to try to skip through, but it talked about her having Swiss bank accounts. It talked about her armed security that was being paid for by her brother. It talked about basically why they chose to go after her for a very specific range of crimes in the 90s, right? A lot of people were saying, why isn't she being charged with all these other crimes that we know took place in Palm Beach? Well, they actually describe that in here. They say that the non-prosecution agreement is completely invalid, not only because it's out of the jurisdiction, which, you know, of course, but because it has nothing to do with those previous crimes. It was kind of a brilliant move, and it's one of those moves I keep talking about, guys, that there is a certain level of law enforcement, right, that are out there to do the right thing. Not every cop is bad. Not every FBI or CIA agent even is bad. The vast majority of them want to do good and are smart enough to do good. But it's where they get railroaded, duped into certain agendas, or at the very upper echelons, basically stopped and compromised. Those are very, very real things. So we're going to read this whole document, more or less. But first, I want to remind everybody, we're fully demonetized on this platform. And guys, we do it live. I brought, basically this mobile workstation with me so that we could continue to do these videos because I think they are so important. So thumbs the video up, subscribe, share, join the Burmis Brigade. Make sure to check out the documentary films that are free in the playlist section. And again, share the info, guys. I just hit the streets of Sioux Falls a couple hours ago just to show everybody how pretty much normal it was. I mean, you got some outliers in there, but there are outliers for sure. And you can also support me on Rockfin. That has another great set of creators, including my boy John Fitch. And the UFC is live tonight in a Wednesday night fight night. So for the main card, that's 10 p.m. Eastern. This week's Mixed Martial Mindset with John Fitch will actually be like a 3-hour watch-along, if it goes that long, of these fights. We'll recap this weekend's fights, and we'll also preview the fights that are coming up this weekend, talk a whole lot of COVID 1984. Let's get to it, guys. So here's the document right here. And again, pretty important document. I guess we'll make it just a little bit bigger because we want to get that other stuff out of there. Boom. How's that for everybody? And why not just get rid of that as well? That's perfect. All right, so let's do it. And again, there is some repetition in here, but for the most part, this document is really important. For instance, when they talk about how there's no reason not to, allow her to be detained, and originally I thought it was going to be an MCC because that was being reported. This is a different detention center. They listed off all these other people that had been denied bail with all these other pre-existing conditions. So kudos to them for this document. It's extremely thorough. The government respectfully submits this reply memorandum in further support of the motion for detention dated July 2nd, 2020, and in response to the defendant's memorandum in opposition. Okay? No reason to read a liar's opposition form, in my opinion. Let me get myself a water. Thumbs this video up, guys. The charges against Ghislaine Maxwell arise from her essential role in sexual exploitation that caused deep and lasting harm to vulnerable victims, At the heart of this case are brave women who are victims of serious crimes that demand justice. The defendant's motion wholly fails to appreciate the driving force behind this case. The defendant's victims were sexually abused as minors as a direct result of Ghislaine Maxwell's actions, and they have carried the trauma from these events for their entire adult lives. They deserve to see her brought to justice at a trial. Yes, they do. Yes, they do. And we deserve for this entire ring to be broken up, by the way. There will be no trial for the victims if the defendant is afforded the opportunity to flee the jurisdiction, and there is every reason to think that is exactly what she will do if released. For the reasons detailed in the detention memorandum, and as further discussed below, the defendant poses a clear risk of flight, and no conditions of bail could reasonably assure her continued appearance in this case. Among other concerns, she is a citizen of a country that does not extradite its own citizens. She appears to have access to considerable wealth domestically and abroad. Her finances are completely opaque, as her memorandum pointedly declines to provide the court with information about her financial resources, and she appears to be skilled at living in hiding. These are glaring red flags even before the court considers the gravity of the charges in this case and the serious penalties the defendant faces if convicted at trial. Lays it right out there, and again, there's going to be some repetition, but they talk about how France isn't going to extradite her, that she put up no dollar amount for this bond, and instead tried to say that she would give up a United Kingdom property, which means absolutely nothing, and that she would be backed up by $5 million by several different unnamed people. You can't make this stuff up. Instead of attempting to address the risks of releasing a defendant with apparent access to extraordinary financial resources, who has the ability to live beyond the reach of extradition in France, and who has already demonstrated a willingness and ability to live in hiding, the defendant instead proposes a bail package that amounts to little more than an unsecured bond. Among other things, the proposed bail package contemplates the defendant pledging as the sole security a property that is beyond the territory and judicial reach of the United States, and which therefore is of no value as collateral. 0. She proposes 6 unidentified co-signers. Oh, I'm sorry, it was 6, not 5. As unknown number of whom even reside in the United States, and none of whose assets are identified. The court and the government have no information whatsoever regarding whether these co-signers would be able to pay the proposed $5 million bond should the defendant flee, or if, of equal concern, the co-signers are themselves so wealthy that it would be no financial burden whatsoever to do so. Ding, 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 ding. The defendant does not identify what residence she proposes to live in the Southern District of New York, nor does she identify any meaningful ties to the area. And most importantly, the defendant's memorandum provides the court with no information whatsoever about her own finances or her access to the wealth of others, declining to provide the court with the very information that would inform any decision about whether a bond is even meaningful to the defendant, and which the government submits would reveal the defendant's financial means to flee and live comfortably abroad for the rest of her life. So they go hard in this bad boy, okay? Finally, the government recognizes that the COVID-19 pandemic is and should be a relevant factor for the court and the parties in this case. However, the Bureau of Prisons is taking very significant steps to address that concern, and the defendant has offered no reason why she should be treated any differently from many defendants who are currently detained at the MDC, pending trial, including defendants who have medical conditions that place them at a heightened risk. And again, they reel them off later on. Inmates at the MDC are able to assist in their own defense, especially long-term trial, through established policies and procedures applicable to every pretrial detainee. The defendant should not be granted the special treatment she requests. The defendant faces a presumption of detention She has significant assets and foreign ties. She has demonstrated her ability to evade detection, and the victims of the defendant's crimes seek her detention. Because there is no set of conditions short of incarceration that can reasonably assure the defendant's appearance, the government urges the court to detain her. I mean, top of the line. I'm telling you, again, these guys knew what they were doing when they wrote this up. They were smart. They address a lot of situations. Guys, thumbs this video up, subscribe, and share. We're going to continue on. So, each of the relevant factors to be considered as to flight risk, the nature and circumstances of the offense, the strength of the evidence, and the history of the characteristics of the defendant weigh strongly in favor of detention, and the defendant's proposed package would do absolutely nothing to mitigate those risks. Agreed. As the court is aware, pursuant to the Crime Victims' Rights Act, a crime victim has the right to be reasonably heard as certain public proceedings in the district court, including proceedings involving release. Consistent with that requirement, the government has been in contact with victims and their counsel in connection with its application for detention. Counsel for one victim has already conveyed to the government that their client opposes bail for the defendant and has asked the government to convey that view to the court. The government also expects that one or more victims will exercise their right to be heard on the July 14, 2020 hearing in this matter. We urge the court not to grant bail. And by the way, that did occur. In fact, Maria Farmer's sister, Annie, did speak at that thing. I know a lot of you guys have listened to some of that. The audio quality is not the best, and that's why I decided to do this document instead. But yes, people heard victims speak out, and those statements definitely hold weight, especially in this case. The defendant's motion argues in a conclusory fashion that the government's case must be weak because the conduct charged occurred in the 1990s. That argument, which ignores the many specific allegations in the indictment, could not be more wrong. As the superseding indictment makes plain, multiple victims have provided detailed, credible evidence of the defendant's criminal conduct. And while the conduct did not take place a number of years ago, it is unsurprising that the victims have been unable to forget the defendant's predatory conduct after all this time, as traumatic childhood experiences often leave indelible marks. Correct. You know, again, these guys were really smart in my opinion. They're really trying to get her. You could argue with me at this, but again, I think that those mid-level people really thought this out. They see how the screw job has happened to them before, and they were really careful on what they're actually charging her with. And hopefully, again, this isn't just a snow job. This isn't a whitewash. This isn't we got one, we're going to get others. I'm hoping. Because, again, the Southern District of New York wants to do this, but can we trust the FBI? Probably not. Can we trust everybody within the SDNY? Probably not. The recollections of the victims bear striking resemblance that corroborate each other and provide compelling proof of the defendant's active participation in a disturbing scheme to groom and sexually abuse minor girls, in addition to compelling victim accounts. As the government has explained, the victims' accounts also corroborated by documentary evidence and other witnesses. In particular, the victims' accounts are supported by contemporaneous documents and records such as flight records, diary entries, and business records. I mean, boom, boom, boom. Love it. The powerful testimony of these victims, who had strikingly similar experiences with Maxwell, together with documentary evidence and witness testimony, will conclusively establish that the defendants groomed the victims for sexual abuse by Jeffrey Epstein. The defendant's motion alludes to defenses in this case, all of which are legal to procedural in nature, and none of which pass the muster, let alone counsel in favor of bail. To begin with, The notion that the defendant is protected from prosecution by the non-prosecution agreement between Jeffrey Epstein and the U.S. Attorney's Office in the Southern District of Florida is absurd. I'm telling you, they knew this was going to be a point, and I really do believe that's why they went with the crimes in the 90s. Very smart. That agreement affords her no prosecution in this district for at least 3 reasons. First, the defendant was not a party to that agreement, nor named in it as a third-party beneficiary. And the defendant offers no basis to think she would have standing to claim any rights under the NPA. Tellingly, the defendant cites no authority for the proposition that an agreement she was not a party to, and that does not even identify her by name, could possibly be invoked to bar her prosecution. Now let's explain that for a minute. So what they're saying is she was obviously protected by that Epstein sweetheart deal we've all heard about, but not even by name. So how is she going to even say that she's protected under that? All right. Second, and equally important, the NPA does not bind the Southern District of New York, which was not party to the agreement. And I like how they cite court cases here. Okay, a plea agreement binds only the office of the United States Attorney for the district in which the plea is entered, unless affirmatively appears that the agreement contemplates a broader restriction, which it does not. This rule applies even if the text of the agreement refers to the signing party as the government. And here it is. Third, and most important, even assuming the NPA could be read to protect this defendant and bind this office, we are both legally unsound, which are both legally unsound propositions. The indictment charges conduct not covered by the NPA, which was limited by its terms to conduct spanning from 2001 to 2007, a time period that postdates the conduct charged in the indictment, and to violations and statutes not charged in this indictment. In this respect, the government further notes that the indictment brought in this district is entirely independent of the prior SD Southern District of Florida investigation. And 2 of the victims referenced in the indictment were never approached or interviewed by the SDFL and had never spoken to law enforcement until met with in our office in 2019. Nor is there any force to the defendant's assertion without explanation, much less legal authority, that the charges in the indictment are untimely. As the government explained in this opening brief, the charges in this case are timely, pursuant to U.S. 3283, which permits the prosecution of crimes involving the sexual abuse of minors at any time during the life of the victim. Damn right they're timely. The defendant's claim that the indictment is barred by the statute of limitations has no basis in law. For similar reasons, the court should not give any weight to the defendant's bare assertions that the indictment is somehow legally flawed in unspecified ways, or that perjury counts are subject to dismissal for unspecified reasons. These conclusory claims are baseless. Boom. Boom. Boom goes the dynamite, folks. There it is. Boom. And now they go over again why they are a flight risk. So they rehash some of the France stuff right here. Yeah, I'm going to skip over some of this stuff, but you can see that, basically this person has extensive wealth and no job. No job that would tie her to the Southern District of New York. Does not have to appear to depend on any job or have depended on any employment for the past 30 years. For the privileged lifestyle she has maintained for the entirety of that period, the defendant clearly has the means to flee. Think about that. The past 30 years, what has she been doing? Okay? They say this underscores it, okay? So let's talk about where they found her, how they found her. If you know, I went over to the driveway, right, to the tucked away rock, and the Guardian was up there. They went up there. I would assume the same bodyguard that was hired by her brother they're going to mention here was the one that they met up with her, but let's just read it. So this is what happened when they went to get her. I know that, there'll be fantasists out there that say none of this happened. This is all scripted. None of it's real. But hey, what can you do? Some people live in a little bubble and don't want to look at evidence right when it's in your face. So again, guys, make sure you're thumbing this video up, subscribe and sharing. Again, hit the GoFundMe if you can. Let's get back into the mix. More troubling still, the defendant's conduct at the time of her arrest further underscores the risk of flight she poses. When FBI agents arrived in the defendant's remote property in New Hampshire on the morning of July 2nd, 2020, they discovered the property was barred by a locked gate. After breaching the gate, the agents observed an individual who was later determined to be a private security guard. As the agents approached the front door to the main house, they announced themselves as FBI agents and directed the defendant to open the door through the window. Okay, because a lot of people said she just gave up, and I said, no, that wasn't the case. Didn't seem that way from the first reports there. Okay. Through a window, the agent saw the defendants ignore the direction to open the door and instead try to flee to another room in the house, quickly shuttering a door behind her. Agents were ultimately forced to breach the door in order to enter the house to arrest the defendant, who was found in the interior room of the house. Moreover, as the agents conducted a security sweep of the house, they also noticed a cell phone wrapped in tinfoil on a top of a desk. A seemingly misguided effort to evade detection, not by the press or the public, which of course would have no ability to trace her phone or intercept her communications, but by law enforcement. Following the defendant's arrest, the FBI spoke with the security guard, who informed the agents the defendant's brother had hired a security company staffed with former members of the British military to guide the defendant or guard the defendant at the New Hampshire property. See that? So former members of the British military protecting Ghislaine Maxwell on that property in rotations. The defendant provided one of the guards with a credit card in the same name of the LLC that had purchased the New Hampshire property in cash. Interesting. So it seems like they're trying to say it was the brother and not the tech boy that bought that. I don't know. The guard informed the FBI that the defendant had not left the property during the time working there, and that instead the guard was sent to make purchases for the property using the credit card. And these facts make plain there should be no question that the defendant is skilled at living in hiding. Okay? The defendants asked the court to ignore many of the obvious indicators of a flight risk by arguing that she has lived in hiding because of unwanted press attention. This argument entirely misses the point. First, the defendant's conduct is clearly relevant to the court's assessment of her risk of flight because it's evidence her readiness and ability to live in hiding and to do so indefinitely. As such, even if her behavior in the last year could be attributed solely to her desire to avoid media attention, that should give the court serious concerns about what steps she would take to avoid federal prison. Second, the fact that the defendant took these measures to conceal herself after Epstein was indicted in this district and after the government announced that this investigation into Epstein's co-conspirators was ongoing cannot be ignored. To the contrary, these measures are at least equally consistent with the notion that the defendant also sought to evade detection by law enforcement. In attempting to sidestep the evidence of her ability and willingness to hide, the defendant points to her decision to remain in the United States for the past year while the government's investigation remained ongoing. She claims that because she did not flee the country during an ongoing investigation, she will not do so while under indictment. This argument ignores the world of difference between believing that an investigation is ongoing and being indicted on 6 counts by a federal grand jury. The defendant now faces the reality of serious charges supported by significant evidence and the real prospect of spending many years in prison. The return of the indictment fundamentally alters the defendant's incentives and heightens the incentives to flee far beyond the theoretical possibility of a charge during an investigation. This is especially so when the defendant has spent the last 2 decades without facing consequences for her criminal actions. Damn straight. For years before her arrest in this case, the defendant likely believed she had gotten away with her crimes. That illusion has now been shattered, and she has a host of new reasons to use her considerable resources to flee. Moreover, the defendant's willingness to brazenly lie under oath about her conduct, including some of the conduct charged in the indictment, strongly suggests her true motive has been and remains to avoid being held accountable for her crimes, rather than to avoid the media, as alleged in the indictment. In 2016, when the defendant was given the opportunity to address her conduct with minors in the context of a civil suit, she lied repeatedly. Those lies are, of course, the subject of 2 counts of perjury, and their evidence her willingness to flout the law in order to protect herself. The defendant lies under oath. Should give the court serious pause about trusting the defendant to comply with conditions of bail. So you got to wonder, man, what is she going to be able to put on the table? Because it looks like they're going for the throat here. I know a lot of people say people are shaking in their boots. I don't know that they're shaking in their boots. I don't know. Just saying. Why are they shaking in their boots? I don't think she has the tapes or any of that stuff. At best, she might give up the wrong information, and then the cover-up crew steps in to clean it up. Oh, boy. In its opening memorandum, the government highlighted the defendant's extensive means to flee and her opaque finances. In her response, the defendant's brief provides zero information about her assets in the United States or abroad. The court should be troubled by this. First, so far as the government is aware, the defendant has not filed out a financial affidavit under penalty of perjury in connection with her application for bail, meaning that the court has no reliable insight into the magnitude of scope of the defendant's resources. However, what the court does have are strong indicia of the defendant having access to enormous resources, including the large property she was found on, the private security guard being retained to live with her on that property, and the multi-million-dollar property in the United Kingdom being offered as collateral. Indeed, it is revealing that the defendant's memorandum declines to discuss her assets or the assets to which she plainly has access. Without knowing the full scope of the defendant's financial resources, it would be impossible for the court to even begin to evaluate whether conditions of bail would mitigate her risk of flight. More importantly, the defendant cannot claim that she has met her significant burden to rebut the presumption of detention in this case when she has failed to provide comprehensive, very financial information under the penalty of perjury. Although the government submits that no conditions of bail could reasonably assure the defendant's continued appearance, the defendant's proposed bail package offers almost no security whatsoever. The defendant appears to have significant assets. She has extensive foreign ties and is a citizen of a country that does not extradite its citizens to the United States. And she is charged with serious crimes involving the sexual exploitation of minors. And yet she asked the court to grant her bail secured only by a foreign property, which provides effectively no security at all. Again, they wrote this up big time. Big time. So basically they talk about how they couldn't grab the property if they wanted, even if they had a judgment. Okay? There's no information on those co-signers we talked about earlier, right? Whether they're friends, relatives, what kind of assets they have. And if $5 million is basically just a drop in the bucket to them, why wouldn't you leave, right? So now here's the Swiss bank transactions I talked to in the beginning of the broadcast. Thumbs the video up, subscribe, and share. The defendant's failure to pledge any liquid assets or to provide detailed financial information about herself or her proposed co-signers is particularly jarring because she appears to have access to millions of dollars, principally in foreign accounts. In recent years, the defendant has been associated with multiple accounts with a Swiss bank, the Swiss bank, and multiple accounts with at least one bank headquartered in England, the English bank. In 2018 and 2019, Form 114 F-bar Submissions on behalf of the defendant filed with the United States Treasury Department list accounts in the English bank with maximum values totaling well over $2 million. In connection with the Swiss bank, the defendant appears to be the grantor of a trust account with a balance of, in June 2020, of more than $4 million. Among other transactions, the defendant appears to have transferred approximately $500,000 in March 2019 from one Swiss bank account in her name to the trust account, and records further reflect a transfer between those same accounts in June 2019 of more than $750,000. The trustees of the trust account, of whom may actually independently, according to relevant trust account documents, appear to include both a relative and a close friend of the defendant. Additionally, the defendant was arrested last week on a property in New Hampshire that was purchased for more than $1 million in cash in December of 2019. It is unknown whether the defendant purchased the property in cash or whether she was a wealthy patron who did so on her behalf. But either scenario should raise concerns about the defendant's access to financial resources that would enable her to flee. Of course. And we're not even done yet. We're going to talk about, again, over a dozen bank accounts this woman may have. Moreover, and as set forth in the detention memorandum, the defendant has been associated with more than a dozen bank accounts from 2016 to the present, and during that period, the maximum total balances of those accounts have exceeded $20 million. Those accounts engaged in transfers in amounts of hundreds of thousands of dollars at a time, including as recently as 2019. To the extent the defendant now refuses to account for her own ownership or access to vast wealth, it is not because it does not exist. It is because she is attempting to hide it. And again, I told you, Epstein was hiding a lot of his stuff too. I truly believe he was a billionaire, maybe even a multi-billionaire. Think about that. Think if he had $2 billion and they only found about $600 million. That's just the beginning. That's just scratching the surface. Okay, basically they say she's a risk because she could just remove the bracelet, all right? And it's happened before, so that argument is absurd. Points out that she has no kids, no immediate family members that she resides with, etc. In other words, she's not taking care of anyone. And although she's close to her siblings, she's maintained remote relationships before, right? And you look at this and the deceptive actions, the foreign countries, the fact that she might not be extradited, and then they go through the COVID-19 and take a look here. Just about every single court case they could put out there, and every single pre-existing condition and health issue you could do, they were citing a case that no, that's ridiculous. See, hypothetical risks. I mean, they go right through them. Look at this. Boom, 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 boom. I mean, they lay it down there. Okay? As the foregoing citations make clear, the defendant in many of these cases asserted underlying health conditions that purportedly placed them at heightened risk. But nevertheless, they were denied. See that? Okay? And then they talk about bail reform and the current inmate situation here. No. So there it is, basically. It's right there. Anybody can go read this document. I think that it revealed a lot of interesting things. Make sure, again, to check me out and support me out over on Rockfin. In fact, today we put out a Rockfin exclusive. You can just click on Jason Burmis. And yeah, you saw Sam Tripoli on there. Can't find it anywhere else. It's free. And we also have another free exclusive from a couple days back. But check out my Cuomo Ain't No Hero video. There's a lot to break down in that video, so I'm just going to tell you to go over there. Remember, Mixed Martial Mindset, 10 p.m. tonight during the main card. That's Eastern. I'm in South Dakota right now. Thumbs the video up, subscribe, and share if you can. $5, $10, $15. It means the world to me, guys. This is how I'm doing it. The GoFundMe. We're fully demonetized on this platform. Check out the documentary films. They're all free. Loose Change, Final Cut, Fabled Enemies, Invisible Empire, A New World Order Defined, and Shade the Motion Picture. I love you, and I will see you all on the flip side.